Lawyers, which vacay gone viral dispute versus Airbnb and airline still drains your sanity today. Story 1. Ironically, I, as counsel, am a lawyer myself, though I no longer practice, and my prior area of expertise had nothing to do with this particular kind of dispute. Still, more on that later. To summarize my client's situation, they booked a last-minute Airbnb in New York City. The listing disclosed the presence of security cameras. At first glance, this wasn't concerning. Many properties have exterior surveillance. However, once the host received the reservation, he sent my client an email asking for confirmation that they were aware of cameras inside the apartment. Given that this was a studio unit, that meant surveillance was occurring in the same space where my client would be sleeping, changing clothes, and otherwise expecting privacy. My client immediately asked the host to call them. In addition to the camera situation, the host imposed a number of other irregular demands, such as requiring a picture of my client's government-issued ID, even though Airbnb handles ID verification independently. While waiting about 20 minutes for the host to call back, my client began reading reviews of the host's other properties. It quickly became apparent that the situation was extremely questionable. Before the host returned the call, my client messaged to cancel. The host refused to honor the cancellation, even though it occurred within 1 to 2 hours of booking, and was based on material information that had not been disclosed in the official listing or house rules. At that point, my client contacted Airbnb. They spent roughly an hour on the phone, speaking with 3 different representatives. The third assured them that they would receive a refund. This was verbally confirmed before my client left to check into a hotel, relying on Airbnb's guarantee. Although my client never visited the property, they provided Airbnb with a screenshot of the host's message as evidence. Airbnb said this was sufficient to proceed, and later that afternoon sent a written notice promising a refund and partial reimbursement for the emergency hotel stay. The following day, Airbnb messaged again, this time stating they needed the host's approval to finalize the cancellation. They added that they would look into it on Friday. This directly contradicted the assurances from the previous day, which my client had relied upon financially. My client called again, and was told they would be contacted soon. After 48 hours passed without response, my client called yet again. This new agent agreed, yes, there had been a violation, and yes, a refund and reimbursement would be issued. My client thanked them, confirmed receipt of the message, and went on with their day. That night, however, Airbnb sent another contradictory message, this time stating no refund would be issued. The following morning, my client again called to explain the situation and was once more told it would be resolved in their favor. Less than an hour after that call, they received yet another message reversing the decision. After more than 10 hours spent on the phone with over a dozen Airbnb representatives, none of whom seemed to have access to previous case notes, my client was still without resolution. This is despite Airbnb's express policies, which prohibit the placement of cameras in sleeping areas and require clear disclosure when cameras are present elsewhere. Additionally, my client made alternative lodging arrangements only after receiving assurances that they would be reimbursed. But the issue is far larger than a single reimbursement. As my client's former attorney and now acting in an advisory capacity, I can attest that they previously worked as legal counsel for survivors of human trafficking. We encountered countless instances where unauthorized surveillance devices were used to track, exploit, and manipulate victims. My client is not claiming that this Airbnb scenario was equivalent, but rather that any normalization of surveillance in bedrooms is a dangerous precedent. In the current socio-political climate, with privacy eroding rapidly, such violations must be taken seriously. My client is exploring next steps and would appreciate any advice from others who've had similar experiences. Through ongoing discussions with Airbnb, it became clear that the company no longer viewed the presence of a camera in the bedroom as a violation, because the host claimed the camera was pointed at the door. At this point, Airbnb had 5 full days of notice about this clear breach of their stated privacy policy. With this listing alone active on over 30 dates, the violation potentially extended across more than 100 guest nights in just 1 week. As legal counsel, I must stress that the ability to remotely operate surveillance equipment significantly undermines any assurance about where a camera is pointed. A remote-enabled camera placed in a bedroom could, with a 1-inch shift, be repositioned to film highly sensitive private activities, changing clothes, walking to the restroom, sleeping. As someone who formerly represented survivors of trafficking and domestic violence, my client has seen the full spectrum of how cameras are abused by predators. When a platform like Airbnb sets privacy expectations, especially when codified in policy, users are legally and ethically entitled to rely on that expectation. Throughout the day, my client also began to hear from others who had experienced similar breaches. They have now initiated contact with a personal injury attorney to explore the possibility of seeking injunctive relief, specifically to compel Airbnb to remove all cameras from bedroom spaces within listed properties. Update in case against Airbnb, where cameras were in my client's bedroom. Originally posted December 13, 2022. My client made a follow-up post to invite public questions, pursuant to a moderator comment suggesting they consolidate updates. In summary, my client booked a studio apartment through Airbnb, later discovering there was a camera inside the bedroom area. At first, Airbnb acknowledged this was a policy violation, offering a full refund and reimbursement of 30% for a last-minute hotel. Then they rescinded the offer. Then they reaffirmed it. Then reversed course again. The cycle repeated multiple times, despite over 10 hours of effort on my client's part to speak with various customer service reps. Escalation requests were ignored. My client attempted to contact Airbnb executives directly, no reply. They then enlisted an online consumer advocacy platform, which agreed to assist in exchange for 20% of any recovery. Still, no response from Airbnb. At that point, my client filed for arbitration as required under Airbnb's terms of service. Within 2 hours of arbitration being filed, Airbnb retained a legal team of 4 attorneys to oppose the claim. This team was likely billing hundreds of dollars per hour per attorney. The clear objective appeared to be intimidation, but my client wasn't deterred. What's especially troubling is the waste of resources. A simple refund would have sufficed, yet instead, the company is incurring far greater legal fees attempting to silence the matter. Filing the arbitration cost $200 out-of-pocket money my client spent in pursuit of justice, not just for themselves, but for all future guests exposed to this risk. My client believes deeply that this is about more than a single customer service failure. They also note critically that Airbnb has since deleted all correspondence between them and the host. My client now advises, always screenshot everything as soon as something feels off. Edited to add contextual notes. My client is a trained attorney, though no longer in active practice. Their legal background was in trafficking survivor advocacy. This matters because they are not pursuing this action out of mere personal grievance. They've seen firsthand how video surveillance in private spaces is used as a tool of abuse. Yes, they had the means to refuse entry and rebook a hotel. But many travelers, especially those who are young, low income, or marginalized, might not. Police involvement may not feel like a safe option for everyone either. Allowing listings with cameras in bedrooms leaves guests with impossible choices: tolerate the violation, hope they can afford new lodging, or risk calling authorities. This is unacceptable. When asked why Airbnb later reversed the refund offer, they first argued that notice had been provided, since the listing mentioned security cameras. But Airbnb's policy explicitly forbids cameras in bedrooms disclosure, or not. When my client raised that, one rep replied, "Well, the host said it's not pointed at the bed," as if that justified it. Anyone familiar with modern camera tech knows that many devices can be remotely pivoted to face any part of the room. This isn't just poor customer service, it's systemic failure. Despite intimidation tactics, my client is moving forward with arbitration and thanks the online community for its encouragement and support. Further context. My client previously worked in legal advocacy for survivors of human trafficking. Many of those cases involved covert video recordings, undressing, sleeping, or worse. Sometimes, survivors had been drugged and recorded in deeply violating scenarios. Is my client alleging that this exact situation would have happened to them? No. It could have, but that's not the point. They had the financial flexibility to walk away and charge a hotel room. Many others do not. Some commenters suggested they could have called law enforcement, but my client understands, especially from their former clients' experiences, that police don't feel like a safe option for everyone. What Airbnb is effectively doing, by allowing this, is presenting guests with three poor options. 1. Stay in a room with a surveillance device where you undress and sleep. 2. Pay out of pocket for new lodging. Or 3. Escalate to police and accept the risks involved. That is indefensible. Several readers asked why the refund was rescinded. First, Airbnb argued that my client had been given notice of cameras, referring to the listing's mention of general surveillance. However, as previously stated, Airbnb's own policies prohibit cameras in private spaces like bedrooms, regardless of whether they are disclosed. When my client pointed this out, the representative responded, "Well, the host said it isn't pointed at the bed." That kind of response ignores the most basic facts about surveillance technology. Cameras can be controlled remotely. A host could reposition a camera at any moment. Airbnb knows this, or should. So my client is continuing to fight. To all who sent messages of support after that moment when Airbnb tried to intimidate them with 4 lawyers, thank you. It made a real difference. In fact, your encouragement helped restore my client's resolve. And yes, it did come at a cost. This post overtook another AMA thread my client had written about their great uncle, a decorated WWI fighter pilot who passed away recently. If you're interested in a story from a real American hero and a hilarious anecdote that still makes my client laugh, here's the link. Jack Hallett's AMA. R. Second update, posted January 27, 2023. Per the rules of arbitration, my client is preparing to move forward in that forum. Airbnb's legal team responded by stating, Airbnb disclaims all liability under its terms of service. Section 18 states the platform and all content are offered as is, with no warranties. Even if Airbnb were liable, the company argues my client waived all claims by agreeing to the terms of service. Airbnb asserts that the damages were caused by a third party, i.e., the host, not the platform. They claim my client consented to everything by signing the 2S. They accuse my client of seeking more than they're entitled to, suggesting they are unjustly enriching themselves by requesting compensation for lost time. Reminder: my client is a professional consultant with subject matter expertise in safety, privacy, and trauma recovery. They raised the doctrine of laches, suggesting my client delayed unreasonably in asserting their rights. In reality, my client contacted Airbnb less than 5 minutes after discovering the camera. Finally, Airbnb alleges my client failed to mitigate damages, which, considering they refused to enter the unit and booked a hotel, may be the most absurd claim yet. So yes, we're going to arbitration. An arbitrator has now been assigned, and a hearing date is forthcoming. Some readers might think it unwise to continue posting while litigation is pending, especially since Airbnb's counsel may be monitoring. But my client is not sharing these updates to benefit themselves personally. Their aim is to make others aware of what can happen even when your complaint involves a clear violation of Airbnb's own policies. It's worth noting that arbitration is intentionally designed to shield corporate disputes from public view. Unlike lawsuits, arbitration decisions are not part of the public record. That's why my client is committed to keeping this matter visible. As of now, Airbnb has incurred $2,900 in filing fees for this case. The arbitrator charges $2,500 per day. Their law firm has 4 attorneys on the matter. They are spending far more to fight this than they ever would have owed. So we must ask why. Why would a company pour this much money into fighting a basic refund claim unless they fundamentally believe it's acceptable to place cameras in private sleeping spaces? Or unless this represents a shift in Airbnb's approach, refusing responsibility across the board, no matter how egregious the facts? My client will keep the community updated on developments. Yes, we know arbitration isn't technically court, but we're taking the wins where we can. UP date, from court, originally posted March 4, 2023. In the most recent development, my client participated in the preliminary arbitration hearing on March honest. The central issues remain unchanged. The presence of a camera in the bedroom of a studio Airbnb listing, followed by a series of contradictory communications from Airbnb offering a refund and reimbursement, then rescinding both, then repeating this pattern multiple times. After exhausting all internal avenues, my client filed for arbitration to hold Airbnb accountable to its stated privacy policy. Here are several notable updates from that arbitration process. Court hearings and memo submission dates are now scheduled across the next few months. The full hearing is set for April 20th. My client declined the option to resolve the matter on the documents, choosing instead to proceed with a full evidentiary hearing. While in-person attendance would require special approval, the hearing will likely take place over Zoom. Though Airbnb originally assigned 4 attorneys to this matter, only one appeared for the telephonic hearing. Airbnb requested permission to file a dispositive motione legal argument that aims to dismiss the case outright, asserting that my client has no valid claim. Legal development. My client has been granted 1 week to amend their complaint. Upon researching available claims, a friend directed them to Massachusetts General Laws, Chapter 93AA, Consumer Protection Statute, offering robust remedies, including treble, triple damages, for unfair or deceptive business practices. As a Massachusetts resident, my client is now preparing to assert a Chapter 93A claim. They invite other legal professionals or knowledgeable community members to suggest additional statutes that may apply. Thus far, efforts to secure outside legal representation have been unsuccessful, but my client remains undeterred. Interesting turn. Toward the close of the preliminary hearing, Airbnb's representative introduced the idea of confidentiality. Specifically, they expressed concern about my client speaking to the press and said they wanted to ensure we were all on the same page regarding public disclosure. My client had expected Airbnb to reference the Reddit posts, but so far the company appears unaware of these discussions. The arbitrator immediately inquired about the legal basis for Airbnb's confidentiality expectation. The company cited a rule stating a judge can issue a confidentiality order. The arbitrator interrupted, noting that he had issued no such order and would require Airbnb to file a formal motion if they wished to pursue one. Should Airbnb seek a gag order, my client will contest it. Transparency is a core component of their advocacy in this matter. Frequently asked questions and responses. Yes, my client has reached out to various press organizations. One prominent outlet nearly pursued the story, but ultimately declined, citing a lack of evidence that this was a systemic issue. If anyone in the community has press contacts, my client welcomes introductions. The goal here isn't financial acts, about making Airbnb reform its surveillance policies. My client is still trying to secure legal counsel, especially in case Airbnb attempts to silence them via legal mechanisms. To date, those efforts have been fruitless. They are continuing pro se, on their own behalf, for now. My client is pressing forward, though the absence of legal representation remains a challenge. The arbitration judge's rejection of Airbnb's implicit confidentiality argument was a win, at least temporarily securing their ability to speak publicly. As the hearing date approaches, we continue to prepare filings and evidence. Meanwhile, my client has compiled the entirety of Airbnb's shifting explanations. They initially claimed my client had notice due to a general mention of cameras in the listing. But Airbnb's own rules clearly prohibit cameras in bedrooms. When confronted with this inconsistency, one representative argued that the camera was not pointed at the bed, as if the direction of a remotely operable surveillance device was a valid legal distinction. To reiterate, Airbnb's own stated policies prohibit surveillance equipment in private spaces like bedrooms, regardless of the angle. The ability to reposition a device remotely invalidates any defense based on current orientation. This was precisely the kind of logic my client encountered repeatedly during their former work representing trafficking and domestic violence survivors. Abusers often made similar rationalizations, claiming devices were inactive or directed away only to exploit control mechanisms later. The hearing remains set for April 20th. We anticipate a fully contested process. Regardless of outcome, my client intends to share their experience as a warning to other consumers. Story 2. As legal representative for this family, I first became involved when the parents of a 19-year-old US citizen contacted me in a state of escalating distress. Their son had just landed at Dulles International Airport in Virginia on an international flight from Munich. At 7:45 p.m., he texted that he was heading to customs. By 11:30 p.m., there had been no further communication. The parents attempted to reach him repeatedly, but his phone was going straight to voicemail. They tried calling the airport and customs offices, only to find those lines closed. The son had flown to Washington, D.C. to attend a cousin's graduation, with the next leg of his trip to Boston. He was expected to take a rideshare to a nearby hotel where family awaited him. However, he never arrived. His last known phone battery status was 65% at 7:45 p.m. The tracking data ceased after that. The family contacted airport police and provided a physical description and flight details, hoping for a callback that night. Given that their son attends the American University in Bulgaria and had arrived on a one-way international ticket, they began to worry that his point of origin or student status abroad may have flagged him for heightened scrutiny. At this stage, they had no indication of criminal activity, immigration issues, or any reason for detention. He has no arrest record, is a U.S.-born citizen, and carried all required identification. As counsel, I found their concern justified, particularly given the lack of transparency surrounding customs procedures that evening. The parents remained hopeful that delays were due to long lines or operational issues. One commenter familiar with Dulles noted that large international arrivals, especially Lufthansa flights from Munich, often create long customs backlogs, particularly if weather causes simultaneous landings. Still, they feared a more serious issue was unfolding. By 1:15 a.m., airport police confirmed their son was still in the customs area. However, they could not say whether it was due to line delays or detention. A customs officer promised to have him call his family when he's able. The family emphasized this young man and his parents are not affiliated with any controversial political movement and have never posted inflammatory content. He had merely been abroad for school. Yet by 4:30 a.m., they received the call they'd been dreading. A voicemail transcript showed their son pleading for help, stating, "The FBI has seized my phone and my computer, and I need help ASAP. I'm at the airport. I don't know what to do. It's like 3 a.m. After receiving the voicemail, the parents still in Boston booked their son a rideshare to the hotel where he was originally meant to meet relatives. He eventually arrived, but remained afraid to speak in detail from the airport payphone. He disclosed that he had been questioned about his loyalty to the United States. Agents had seized both his phone and laptop, stating that he might receive them back within a couple of days. When asked by online commenters whether the family was sure he had attempted to call earlier, the mother clarified that she had picked up but the call connection was poor. She attempted to redial, but the call went to voicemail. Some speculated that his attendance at an American university in Bulgaria could have flagged concern, mistakenly associating Bulgaria with espionage activity. While these comments were largely speculative and inaccurate, especially considering that the university is well respected, my client does wonder whether his arrival on a one-way flight from an Eastern European nation may have contributed to a profiling decision. Notably, the son had no criminal record and held valid student credentials. He is a lifelong U.S. citizen, born and raised. A separate commenter flagged a prior Reddit post made by the mother regarding espionage consequences, suggesting possible relevance. She clarified that this post was unrelated, simply the result of her interest in crime stories and recent news, not reflective of any actual circumstances involving her son. Around 9 a.m. the next morning, a local Redditor living near Dulles reached out and offered their number in case the young man needed assistance. The mother responded gratefully, stating she was en route from Logan Airport to D.C. An hour later, she posted again to confirm, "This post is legit. I'm heading to D.C. We're getting a lawyer, but beyond that, I don't know." Her intent at that stage was to speak directly with her son, assess his condition, and determine next steps. While she personally would have been inclined to publicize the incident immediately, she acknowledged that her son at just 19 was frightened, and any future steps would need to take his safety and comfort into account. By the evening of May 15, after finally speaking with him in full, she issued a public update. The son explained, upon arriving at the customs booth, he was asked standard re-entry questions. After reviewing his documents, the officer inserted a yellow card into his passport and directed him to another screening area. There, he waited with approximately 10 others while travelers were called into side rooms individually. His bags were searched several times, and he was asked multiple times if anyone was waiting for him outside. He said Noe planned to Uber to a hotel. Eventually, two individuals identifying themselves as FBI agents arrived. They questioned him repeatedly about his views on the US president, his stance on terrorism, and memes he had liked on Instagram. They would send him out, then call him back in for further questions. Each time, they asked again whether someone was waiting for him. This pattern went on for hours. Ultimately, he was told he could leave. However, his phone and laptop were retained for further inspection. He was instructed to use a payphone to contact his family. Fortunately, he remembered his mother's number. In total, he was detained from roughly 8 p.m. to 4:30 a.m. over 8 hours. No formal charge was ever communicated, no cause was identified. No specific affiliations, activities, or behaviors were cited. From what we can tell, they were trying to find something and found nothing. Following the ordeal, the family continued documenting events to preserve the full timeline. When asked by a commenter about official documentation of the detention, they shared that he had received a written form stating "border search" as the reason for his prolonged hold. No other explanation was provided at the time. He was explicitly told to use a payphone to call his mother, further emphasizing that his personal property remained in government custody. Several days later, on May 18, the family released another brief update. They clarified that their son was of Caucasian appearance, a quarter Asian, but self-identifying as white and appearing so. They reported that a senator's office had informed them that the stop was likely a random pull. While this may have been the official position, the context of his background and experience abroad left the family skeptical. At that point, they had secured a consultation with an attorney specializing in federal border issues and electronic device seizures. Multiple members of the media had begun reaching out, but the family indicated they were withholding further public commentary until after legal review. They expressed deep gratitude for the community's support during what had been a chaotic and deeply stressful experience. As legal counsel, I can affirm that the constitutional implications, here particularly under the Fourth Amendment, and related case law governing border searches of digital devices are complex and contested. Nonetheless, my client's family is exploring all options to clarify their son's rights, safeguard his privacy, and prevent recurrence. Story 3. I represent a client who was charged $150 for an alleged smoking violation by a Holiday Inn located across from the Great Lakes Crossing outlets in Auburn Hills, Michigan. My client asserts and has consistently maintained that they have never smoked anything in their life. Upon discovering the charge, my client and a companion calmly approached the hotel manager to request details and evidence supporting the claim. Instead of documentation, they were met with a series of unsubstantiated accusations. The manager claimed that a fire alarm had been triggered, that towels were discovered blocking the door and fire detector, and that fire authorities could allegedly provide a time log of the incident. However, when pressed, the manager was unable to provide a specific timestamp or produce any actual evidence. Moreover, the staff member who allegedly discovered the issue was conveniently absent during this confrontation. The situation escalated when the manager made a blatantly prejudicial remark directly to my client's friend, who is black. He stated, "This is what you do at every hotel," implying a pattern of behavior based purely on discriminatory bias. My client found this deeply offensive and indicative of a broader issue beyond the unfounded smoking charge. Importantly, my client has retained video evidence documenting the exchange with the hotel manager, including the moment he repeated these unverified claims. This footage may serve as critical proof if legal action becomes necessary. At present, we are exploring available legal remedies, including disputing the charge directly with the credit card company and evaluating claims under both consumer protection statutes and possible civil rights violations. Story 4. I represent a client who experienced a break-in and theft while staying at a resort-style hotel. During the night, two unauthorized individuals believed to be unhoused gained entry to my client's hotel room and stole a wallet containing personal identification, driver's license, multiple credit and debit cards, and several $100s in cash. The incident occurred while my client was asleep. Notably, the hotel room door did not latch or lock properly that evening, a failure that directly compromised guest safety. The resort's overall security protocol was also deficient and site staff was minimal, and access to buildings could be easily bypassed by following other guests with key cards, a practice known as tailgating. The theft was only discovered when my client awoke to find unauthorized charges on their credit card. Acting swiftly, my client contacted the first merchant where the card had been used. That store's employee described the suspects and confirmed that they appeared to be unhoused individuals. Hotel security instructed my client to file a police report and stated that they would review surveillance footage. However, as my client had a flight scheduled that morning, they were forced to depart before any resolution was provided. While my client acknowledges that the physical loss was limited to a wallet, the emotional toll and potential for identity theft remain serious concerns. We are currently evaluating the hotel's liability based on failure to maintain secure premises, negligent security practices, and whether they fulfilled their duty of care to guests. If the hotel's response is unsatisfactory, legal action may follow. We welcome any additional guidance from those familiar with premises, liability, or relevant case precedents. Story 5. I represent a client whose reservation at a hotel in Maine was cancelled upon arrival due to the presence of their guide dog. The room had been booked under a promotional rate that was listed as non-refundable, and the client and their family were traveling specifically for a planned trip that was to begin that day. Upon arrival, hotel staff immediately requested a pet fee. My client explained that this was a service animal covered under the Americans with Disabilities Act, ADA, and therefore not subject to pet fees. In response, hotel staff demanded additional documentation including ID from a training program, rabies records, and a doctor's letter. My client produced rabies documentation but declined to furnish the other records, citing federal protections under the ADA, which prohibit such demands. Despite this, hotel staff refused to allow check-in and stated the room would not be refunded. When my client protested that they had been denied access to a room they were legally entitled to occupy, staff threatened to call the police. My client left the lobby and called the hotel from the parking lot to attempt resolution through other personnel. These efforts were unsuccessful. The manager reiterated that the owner had ordered them to refuse entry and no refund would be issued. As a result, my client and their family had no choice but to return home. With their limited budget, they could not afford to book another room. The non-refundable nature of the promotion became irrelevant since the hotel itself voided the contract by refusing lawful accommodation. Subsequently, my client shared additional details. The family had been exhausted from traveling and was relying on the reservation. The room cost, approximately $200, was a significant part of their vacation budget. This wasn't a case of last-minute cancellation due to personal reasons. It was the hotel unilaterally denying access because of a guide dog in violation of the ADA. My client has endured numerous denials in the past, despite long-standing legal protections for service animals. While they are experienced in asserting their rights, the real issue now is the lost funds. The Department of Justice, already backlogged, is unlikely to act swiftly. Accordingly, we are assessing civil options to recover the cost of the room and ensure compliance from the business involved. Story 6. I represent a family who recently attended a wedding at a resort in Cancun, Mexico. During the event, an unexpected rainstorm passed through, resulting in water damage to outdoor wedding tables. Following the reception, either the resort itself or the contracted table vendor contacted the bride-me client's sister-in-law and demanded $19,000 in damages. This demand was made suddenly and without opportunity for review. The bride had signed a document shortly before walking down the aisle, which staff described as a standard waiver covering general event-related issues. She was not given time to consult her fiancé, who was already at the altar, and did not understand the waiver to include liability for natural weather damage. Initially, the fee was unitemized and unsubstantiated. The $19,000 charge appeared in the hotel's internal billing app without prior discussion. Our clients were shocked by the escalation. Notably, the demand began at $60,000 and was then reduced to $20,000 before the resort eventually offered to settle for $1,800. This drastic reduction demonstrates the arbitrary nature of the original demand and suggests it may have been intended to pressure guests under emotional stress. The bride and groom declined to pay the fee. Upon checkout, they were asked to sign a form acknowledging refusal to pay this specific portion of the bill, though they paid for all other services. My client's family reviewed this second waiver in detail before signing and ensured that it did not admit liability. It appears this practice may be part of a pattern. The resort's behavior raises serious concerns about good faith contracting and informed consent. The waiver presented to the bride was vague and made no mention of damage due to acts of nature, such as rain. Furthermore, the resort's willingness to reduce the fee by over 95% suggests a lack of legal or contractual basis. Our clients' passports were never held, nor were there attempts to detain them at the airport. However, such threats have been implied in similar situations abroad, and we are exploring whether this constitutes deceptive business practice or attempted fraud under Mexican or international law. The couple has since departed safely to begin their honeymoon in Costa Rica. We advise other travelers to carefully review all documents presented at destination events and to ensure liability terms are explicitly spelled out in advance. Story 7. I represent a client who was promised participation in a group trip to Japan in 2019, organized through a personal acquaintance operating an informal travel agency. The organizer, let's refer to him as Adam, was a long-time friend of another participant, John, who had invited my client to join. The group consisted of 4 individuals: Adam, John, my client, and a 4th person, Sarah. The package deal included airfare and hotel accommodations for approximately 2 weeks, priced at $1,700 per person. However, after the onset of the COVID-19 pandemic, the trip was postponed repeatedly. In 2021, Adam informed the group that the airline tickets were set to expire. He proposed consolidating all participants' funds into a travel voucher to preserve the value. My client, acting in good faith, agreed. Over the next year, updates became infrequent. When my client eventually asked if there was any possibility of a refund due to ongoing uncertainty and emerging financial pressures, Adam responded that the voucher was non-refundable and could not be partially redeemed. It would have to be used in full. My client accepted this explanation, under the assumption that the trip was still being planned. Several months later, my client saw a social media post from Adam referencing a new Japan trip with an expanded group. Notably, my client was not included. Upon inquiry, Adam claimed he believed my client wanted out, to which my client immediately clarified, "Not without my $1,700. My client later asked whether someone from the new group could buy out their original spot, as they urgently needed the funds. Adam stated that the original 4 names were fixed on the voucher and could not be modified without incurring a fee. He further claimed that such a fee might be waived by late 2023. In early 2024, my client reached out again to confirm the trip status. John informed them that only he and Adam were still attending, and that the departure was scheduled for March. When confronted, Adam reiterated that my client had repeatedly asked to leave the trip despite clear communications from my client that they only wished to exit if they could receive a refund. Sarah, the 4th participant, later confirmed that she was no longer friends with either Adam or John, and she too felt misled. She expressed an interest in pursuing legal action. Although Adam had initially presented his operation as a travel agency, we have since determined that he is not affiliated with any licensed travel business. His services appear to be informal and not registered with the Better Business Bureau or state oversight entities. At present, my client resides in upstate New York and retains full documentation of all conversations, transactions, and related communications. We are preparing to pursue a claim in small claims court for the full value of the funds, based on breach of contract and misrepresentation. Story 8. I represent a client who is now facing serious reputational damage following a highly distressing incident involving 2 acquaintances referred to here as Friend A and Person A during what began as a social outing. My client, who had been asleep in the back seat of a vehicle, awoke to a chaotic scene in which Friend A was yelling to be taken back to a hotel room. Person 1 was refusing and expressed fear that Friend A might become physically aggressive. While parked in a gas station lot, an extended confrontation unfolded. Friend A attempted to exit the car, and Person 1 physically restrained her with both arms. My client intervened and attempted to pry Person 1's fingers loose but was unable to break the grip. After what they describe as roughly an hour of escalation and de-escalation, friend A re-entered the back seat, visibly distressed. My client tried to comfort her physically and emotionally during this time. Friend A then threatened to contact law enforcement, prompting person 1 to seize her phone. My client, trusting friend A and wishing to assist, immediately handed over their own phone so that a call could be made. Eventually, person 1 agreed to return them to the hotel. The following morning, my client attempted to check on friend A's well-being, but was met with hostility and accusations. Later that weekend, friend A sent a message accusing my client of laughing during the incident, failing to intervene, and even insinuating complicity in the alleged assault. The message contained graphic accusations, including that my client had stood by while friend A was groped, allegations my client emphatically denies. They contend they were trying to remove person 1's hands and were unaware of any inappropriate touching beyond the visible restraint. Subsequent to that message, my client was publicly discredited by friend A. Word of these accusations spread, leading to numerous individuals unfollowing or cutting off contact, including a best friend of several years, who cited disappointment without further clarification. My client is a public figure within their community and social media presence. The resulting reputational damage has been swift and severe. They report ongoing emotional distress, fear of social spaces, and a sense of exile stemming from allegations they believe to be false and defamatory. We are currently evaluating whether these actions rise to the level of actionable defamation. Key factors under review include 1. The verifiability of the claims made, 2. The scope and impact of the audience reached, and 3. Whether the accusations were made with knowledge of their falsity or reckless disregard for the truth. If the statements are found to be false, harmful, and made negligently or maliciously, my client may have grounds to pursue civil recourse. Given the reputational stakes involved, we are also considering possible injunctive relief or a cease and desist if the accusations continue to circulate.